Here's a question I get asked almost daily. Well, I was involved in a crash and I was hurt, but I have nearly no property damage or very slight property damage to my car. Do I have a case? The simple fact of the matter is, while the insurance company will have you believe that that's the beginning, the middle, and the end of the conversation, it's often just the very beginning. But I can tell you that I have represented many clients who have ended up with million or close to $1 million verdicts, and they had no damage to their vehicle. Simply stated, property damage isn't the beginning, the middle, and the end of your case, even if that's what the insurance company will have you believe. If there's a good explanation as to why you have the injuries you have, and yet there's no damage to the car, that might be acceptable. But every one of these cases is on an individual basis, and cases like this, like snowflakes, are all different. What you need to think about is getting a consultation, because if you're a person who has prior injuries and no damage to your vehicle, and maybe some better explanation as to why you were having problems in the run-up to the motor vehicle crash, you may very well not have much of a claim, or at least not a claim that my office would consider handling. There are many occasions where folks have a very explainable reason, or physics would demonstrate why there's very little damage. A car that hits you could go under your vehicle and could result in substantial damage to that vehicle, but nearly no visible damage to yours. Or in a case that I recently tried with a jury verdict over $2 million, the jury was persuaded by the fact that my client had nearly no damage to the back of his vehicle, but had a long trailer hitch. And when the vehicle rear-ended my client, that trailer hitch went through the front of the other car, went through the motor, pierced and tore through metal and steel, and totaled the vehicle. Well, all that had to happen in that case was we had to explain appropriately to the jury why, if metal and steel and frame and a whole car can effectively be killed in a crash, why would it be hard to believe that a person with flesh and bone wouldn't have sustainable injuries in the same ordeal? And in that case, the jury saw things the right way and awarded substantial compensation, and believe me, didn't consider the property damage at all. But for every one of those cases, there are the other cases, and I have to have a heartfelt discussion with a client at some point that says, look, I'm not saying you don't have injuries. It's just that the makeup of both the injuries, your pre-existing condition, and even the car damage itself really makes it very, very risky for you to pursue the claim. I think that one of the things that I have an obligation to do in my practice is to say things straight and to tell you straight what I think I can do, but also what I don't think I can do, or what I'm not sure I'm persuasive enough to convince folks of. And I hope you understand that even if I don't take your case, I will still spend the time to professionally look at your case and give you a respectful response to my judgment and what I see happening in your case. Don't be discouraged simply because you don't have property damage. But be mindful that the insurance company is going to be looking and going to be treating that probably as the beginning, the middle, and the end. This is a great time for you to go talk to an attorney.